afternoon. Thank you all very much for coming and obviously for giving up your Tuesday lunchtime. I'm going to talk today about gross misconduct dismissals. The intention is to speak for about half an hour or so. Also try and deal with any questions that you have either as they arise or more likely at the end. Now, I haven't done slides for this particular talk for reasons that hopefully will become clear. If it would help people to have sort of a summary or a handout at the end, I'm happy to produce one just in terms of an outline. I'll explain why that is in a moment. Firstly, I should just say it's the first time I've used Zoom for a webinar, so I apologise in advance for any technical issues. If there is any issue with the connection or anything like that, do say so in the chat. There are 2 points just to raise at the beginning. Firstly, if you have any questions, there is a Q&A box at the bottom. I'm told that it is more helpful if the questions go in the Q&A because then I will see them as opposed to them getting potentially lost in the chat. That's the first point. And secondly, if you are using the chat, obviously by all means feel free to do so. The default setting is that apparently that your messages only go to the panelists, i.e. me. If you want your messages to be seen by everybody, then I think you need to change that to say panelists and attendees. And that seems to be something in Zoom that I can't change. So if that's what if you want to chat to the group, then that's what you'll need to do. So just to give you a little bit of background about me, obviously I'm an employment law barrister at Pump Court Chambers. I've been doing that for about 5 to 6 years, but as may be apparent, I'm not 28. Prior to coming to the bar, I was in a previous life, I was an employer for some 12 years, and I used to run my small to medium-sized family business. It was in quite an old-fashioned industry, the printing industry, one which has, as you may know, quite a long history of quite robust unions. And so I had a number of years as managing director of that business where I was responsible also for the HR, about 80 staff. So I've not only defended unfair dismissal claims involving gross misconduct as a barrister, I've also been there at the coalface. I've done disciplinary hearings, I have dismissed staff for gross misconduct. And I think that has given me a rounded perspective on this area. And I'm acutely aware of the real world issues that employers face in dealing with these issues on a day-to-day basis, as opposed to in the sort of rarefied atmosphere of the tribunal. Now, obviously, at the risk of stating the obvious, the best way to avoid a claim for unfair dismissal is to have dismissed fairly in the first place. But as we all know, you can't stop someone bringing a claim. Even if it's got poor prospects or no prospects or is vexatious, you can try and strike it out. You can try for a deposit order, but there's no guarantee that you're going to succeed. So what you can do is be well prepared to defend the claim and as well prepared as possible. And of course, that work happens well before the claim is brought. Indeed, it happens before the dismissal. Now, a lot of this is common sense, and you may think that some of it falls into the category of the bleeding obvious, but you would be amazed how often employers, in my experience, do get these things wrong. And it's for that reason that I haven't done a sort of a detailed handout. It's not lots of case law. It's more a question of if you find something helpful that's a takeaway for you, then great. As opposed to needing to sort of write everything down, because hopefully, obviously, some of this will be known to you already. But I suspect the reason that this happens, the reason employers make these mistakes is because at the time when these issues crop up, no one thinks it's going to lead anywhere. And then suddenly you're in a tribunal with a 400-page bundle, and you've got a judge and a barrister for the claimant going all over the documents with a fine-tooth comb and asking you and your staff a lot of awkward questions. And then, of course, the flaws and the problems, they will just leap out at you. And so many times in tribunal, employers said to me, if we'd known we'd be here 2 years later still dealing with this, we'd have done it differently. So the time and the effort that's put in at the outset does pay dividends, and I want to give some examples of that as I go along. But my first piece of advice really would be, insofar as it is possible, and I appreciate this is a bit aspirational, but try to approach staff issues, particularly grievances, disciplinary hearings, as if it is going to end up with the employee leaving. Now, obviously, most of the time that won't happen, but as we know, it doesn't have to be a dismissal that results in a claim. Obviously, I'm not dealing with constructive unfair dismissal today. I would point you to Ezra McDonald's recent webinar on that subject. But you can equally easily end up with a resignation, an alleged constructive dismissal, even if you had no intention of dismissing the person. So in terms of how employers address these issues, and particularly disciplinary issues, and obviously if you're advising those employers, take it seriously. Don't cut corners, because you never know which one of these situations is going to ultimately turn into a claim that's going to cost you money to defend, even if you win. And so in terms of what I'm going to talk about, well, obviously I do need to touch on the law, but this is, as you will appreciate, a very well-known and settled area of employment law. And for that reason, I don't propose to spend a long time on it. And I also don't propose to give you a long list of authorities, because as we all know, these cases invariably turn on their facts. So what I want to focus on really is the sort of practical issues which come up in tribunal time and time again, with a view to really giving some pointers on how to deal with the disciplinary hearings and the dismissals at the time, so that those issues don't then arise if you get as far as a claim. And so for that reason, this is really aimed at, as I say, both at employment lawyers who are advising respondents and also obviously HR professionals advising employers. And I think in the blurb that we sent out, there's a number of bullet points just listing the things I'm going to focus on. What is a reasonable investigation? Looking at procedural fairness in practice, framing the charge and this issue, the importance of precision, and this is a key issue. And then how you apply the band of reasonable responses, looking at obviously the issues of where you've got long service or a clean disciplinary record and how far that takes you, and also just the overall reasonableness and of a dismissal and alternatives to dismissal. And as I say, those are not really headings, but I will deal with those as we go along. So I want to start really with a sort of with the standard list of issues that a tribunal will be considering in an unfair dismissal claim. This is not new. This is taken from a recent judgment in one of my cases, but it's based on obviously the Employment Rights Act and the leading case of Berkshire. We all know this. But the first question obviously is going to be, was the claimant dismissed? Now that's obviously not normally an issue, say when you're dealing with constructive dismissal. And the second question is obviously, what was the reason or the principal reason for the dismissal? Now again, in the context of the sorts of cases we're talking about here, it's not usually disputed that it's conduct, but of course the burden is on the company, is on the respondent to prove that it was for a potentially fair reason. And this issue of the reason for dismissal, it does need to be borne in mind throughout, and particularly when drafting the dismissal letter. And we'll come back to that, because you would be amazed how many disciplinary outcome letters don't spell out clearly enough why the claimant was dismissed, particularly where it's not clear, for example, whether it's capability or conduct that's the issue. And so we will come back to that issue of being precise in how you frame the charge later on. So that's the second question, obviously the reason or principal reason for dismissal. And then obviously it's the standard questions that come from Berkshire that we all know. Did the respondent genuinely believe the claimant had committed misconduct? And of course it doesn't need to be a correct belief. For these purposes, a genuine but mistaken belief that the employee is guilty of gross misconduct will suffice for establishing the reason. But then obviously we go on, the tribunal is going to go on to consider whether the respondent acted reasonably in all the circumstances in treating that, i.e. the misconduct, as a sufficient reason to dismiss the claimant. And in particular, whether there were reasonable grounds for that belief, whether at the time the belief was formed, the respondent had carried out a reasonable investigation, whether the respondent otherwise acted in a procedurally fair manner, and whether, of course, dismissal was within the range of reasonable responses. Now, so far, so obvious. But the key word, obviously, that leaps out of all of this is reasonableness. And that goes to the investigation, it goes to the belief in misconduct, and it goes to the decision to dismiss. And the reasonableness of all three of those will often stand or fall by the reasonableness of the investigation, because if you haven't done a reasonable investigation, it's highly likely that your subsequent belief in misconduct won't be reasonable either, and obviously then the decision to dismiss is going to be undermined by that. The reasonableness of that decision is also going to be in question. So the investigation is key. And this is what I mean by putting in the time and effort at the outset, because obviously at the time of the investigation, you're not usually expecting to find yourself in a tribunal, but being alive to that possibility and acting accordingly can be so helpful. And obviously the range of reasonable responses test we know applies to the investigation as well as the dismissal. It isn't for the tribunal to substitute its view as to what's reasonable. And obviously what is reasonable is going to depend on the circumstances, but it's always going to be preferable to err on the side of caution, because not doing enough and then trying to persuade the tribunal to overlook the gaps and find it was reasonable in the circumstances is far more difficult undertaking. So to look at those first two issues, what is a reasonable investigation? What does procedural fairness look like in practice? I want to just consider both of these as we go along. And it is helpful, I think, to put yourself in the employee's shoes, particularly I think if you're an HR professional or someone who's doing this all the time. It is easy to forget this is a person whose job is on the line. They invariably believe that they are not guilty of the allegations against them. If that was you, what would you want your employer to do to investigate? And so when we're looking at what a reasonable investigation entails, well, the obvious place to start is going to be the ACAS code, because the last thing we want is a 25% uplift on any award. But as you'll be aware, the ACAS code is not actually that prescriptive. Obviously, you've got the guidance that's not binding, but the code itself doesn't contain that much in terms of information in terms of exactly what you are and aren't meant to do. And it's often the case claimants will allege procedural failings as being breaches of the code that simply aren't. So it's worth reminding ourselves just what the code actually says. This is in terms of disciplinary hearings, paragraph 5. It's important to carry out necessary investigations of potential disciplinary matters without unreasonable delay to establish the facts of the case. In some cases, this will require the holding of an investigatory meeting with the employee before proceeding to any disciplinary hearing. In others, the investigatory stage will be the collation of evidence by the employer for use at any disciplinary hearing. So first obvious point, don't delay. Apart from anything else, this reduces the chances of the claimant alleging that there has been collusion between the witnesses in the meantime, which you often see. And for that reason, you don't want to necessarily tell people why you want to see them, or tell them what the allegations are in advance. And if it's possible to conduct the investigation meetings in quick succession, then again, that's desirable to do so, because you just don't want them to be open to say everyone was talking about it for days and then they pulled us all into a room. Secondly, again, coming out of the ACAS code points, it doesn't follow that you need to meet with the employee as part of the investigation. Now, the claimants will often complain, employees will often complain if you don't do this, because they will think that that's unfair. But it really does depend on the nature of the allegation. Sometimes having an investigation meeting with the claimant where they get to put their side of the story just involves effectively running the disciplinary hearing twice, and it's a bit pointless and it can cause problems. But there is an obvious benefit to meeting with the employee as part of the investigation, in that they may well flag points or evidence or witnesses that you want to take into account before even deciding if there's a case to answer. Because if you don't do that, and you don't have to do that, the code makes it clear you don't have to do that. But if you proceed to a disciplinary on the evidence that you've got, and then you put it to the claimant, there is the risk that obviously they will raise new matters during the disciplinary hearing that you'll then have to adjourn to investigate further, and that will drag the process out. So it is worth giving thought to whether to involve the claimant at the investigation stage. Just while we're on the ACAS code, it goes on at paragraph 6 to say that in misconduct cases where practicable, different people should carry out an investigation and a disciplinary hearing. Now that seems obvious, and indeed it is, but I would just say bear in mind that this also applies, or can or should apply, to those who take the minutes. Because this is particularly an issue for small businesses or employers. I've got a recent case where we had an HR manager who conducted all of the investigations, but he was then present as the note taker in both the disciplinary and the appeal hearing. And you're left trying to persuade the tribunal that that person didn't have any involvement in the decision to dismiss. Now, the tribunal in that case accepted that evidence, but you've left yourself open to that point by having the same person involved. So obviously think about who's involved in the two hearings and in the investigation, and obviously bear in mind you've got to keep somebody senior in reserve for an appeal. And obviously this will depend on the size of the organisation, but if you can have different people involved, then obviously you want to, and we'll come back to that. Again, still on the ACAS code, it says this: if there's this is paragraph 7, if there's an investigatory meeting, this should not by itself result in disciplinary action. Although there's no statutory right for an employee to be accompanied at a formal investigatory meeting, such a right may be allowed under the employer's own procedure. Now, your own experience will probably tell you employees are notoriously bad at being able to distinguish the difference between an investigation meeting and a disciplinary. No matter how many times you write to them saying this is only an investigation meeting and it's not part of the disciplinary process, they will invariably think it is. And so when you're being seen to be reasonable, which obviously is the watchword of this whole process, it doesn't hurt to allow them to be accompanied at earlier meetings. It will obviously depend on your organisation and your policies, but it's certainly worth considering. But obviously you don't have to. And then the paragraph 8 of the ACAS code: in cases where a period of suspension with pay is considered necessary, this period should be as brief as possible, should be kept under review, and it should be made clear that suspension is not considered a disciplinary action. And that is all pretty standard, but it does go without saying that if you are going to suspend the employee, firstly, you need to be prepared to say why you think that's necessary. Because they're often going to be very aggrieved about that. There's obviously reputational impacts at work, they're standing amongst their colleagues. Everyone will know, no matter how confidential it's supposed to be. So even if your disciplinary policy allows you to suspend, and obviously it usually will, do be prepared to justify that decision with reasons in writing, ideally in a suspension letter that's sent at the time. Now that is the sum total of what the ACAS code actually says about disciplinary investigations. So bear in mind when you've got somebody suggesting that they are entitled to an uplift for failure to follow the code, it's got to be linked to one of those specific provisions. But obviously there is a lot more that you can do to cover yourself against allegations of procedural unfairness further down the line. So as I've said, just want to consider some of the practical points that arise. And these are really things that have come out in cases that I have done. And that, so this is real world sort of examples of things that do actually crop up. So the first obvious practical consideration is, well, how much investigation is needed? Obviously that's context sensitive, but the starting point is, what is the allegation? So this is a conduct issue. It's going to relate to the employee's behavior. How serious is the allegation? Because obviously potential gross misconduct offences are going to require more investigation. How strong is the prima facie case against the employee? I mean, if you've got CCTV of them attacking another member of staff or stealing from the till, that's going to be a relevant factor, but as we all know, that's exceptional. And again, if the employee accepts the misconduct, obviously you don't usually need an investigation at all, but that's pretty unusual. In most situations, you've got a situation where the misconduct's been reported by someone else. So at least one other person's aware of it or has witnessed it. Were there any other witnesses? I mean, not just staff, obviously consider were there customers, were there suppliers on site, members of the public? You know, misconduct can occur in all sorts of different contexts. It isn't just a question of talking to colleagues. And obviously, is there other potentially relevant evidence? I mentioned CCTV, but obviously emails, phone recordings. There's all sorts of potential evidence that you will want to consider in deciding, you know, what's reasonable in terms of, particularly when we're talking about an allegation of gross misconduct that could result in someone losing their job. Because obviously, where you've got that sort of potential ultimate sanction, and it may come down to one person's word against another, you obviously want as much evidence and independent evidence as you can get. So again, this falls into the category of stating the obvious, but talk to all the witnesses. If there are people who can give evidence, then you need to have spoken to them. I did a case recently. There are 2 incidents in one day that were in 2 offices. And in one of those incidents, it was in the claimant's line manager's office, and he went off and was abusive to his line manager. But there was another manager present in the room, and the respondents' HR people didn't speak to that person, or rather they didn't take a statement from them. Because they were going away on holiday for a week. I spoke to them briefly on the phone, but they thought the line manager's work was enough, and they just went ahead. And that's needlessly giving the employee, or in this case the claimant, a stick to beat you with, because this was a case where the employment tribunal, they found that for that reason alone, and despite the fact that he was totally at fault for his own dismissal in terms of his conduct, it was found to be a procedurally unfair dismissal. And so that employer has now got an unfair dismissal finding against them. It's available online, which just didn't need to happen. Now, I should say, well, there was a question before we started about Polkey. This was a case where the employer, the tribunal, I should say, sorry, found that a fair dismissal would have taken another week, because all the employer had to do was wait for that manager to get back, take the statement from them, and then there would have been a fair dismissal. And so they awarded a week's pay as compensation. So Polkey still obviously has a role to play there, but this was just something that did not need to happen in terms of, you know, as I say, it sounds obvious. I say talk to the witnesses, but don't assume that the evidence you've got is enough if there's other evidence available. And that will obviously include speaking to any witnesses that the employee thinks are relevant. Now, there's a danger there, of course, that what they consider to be relevant and what you consider to be relevant won't be the same thing. But if you do conclude you don't think that the people they want you to talk to can add anything, well, obviously do be prepared to say why not. And it's always going to be better to err on the side of caution and just have an investigatory meeting with someone who can't give relevant evidence than to be seen to ignore something that the claimant thinks is potentially relevant. So we've talked about how much investigation is reasonable. Who should conduct the investigation? That is, again, a very important consideration. And you need to bear in mind, of course, that there are 3 stages to a disciplinary. You will need an investigating officer. You will need a disciplinary officer who really wants to be a different person. And of course, you need an appeal officer. They all want to be different people and ideally senior to one another. Or certainly the appeal officer needs to be senior to the dismissing officer, who needs to have sufficient authority to dismiss. Now, obviously, in terms of the investigation stage, well, if you've got HR people, then obviously you want to use them. But a lot of the time in businesses, especially smaller businesses, you're dealing with well-meaning managers. Make sure you can rely on these people. Make sure they're briefed on what's expected from them. Give them an outline or a script if necessary. And think about how you talk to the witnesses. Because again, the investigation, I've said, is the beginning of all of this, and it's so central, and you're so often trying to, in tribunal, deal with flaws and problems and gaps that have occurred in the investigation stage. So if you can ensure that these don't become a problem from the outset, it will make life so much easier. So think about, as I say, who to talk to. Think about how you talk to them. Make the questions open. Now, you're not expecting your HR people or your managers to be barristers, but so often you see that they go in with a preconceived idea and they put it to the witness. So you will see in the notes things like, Fred punched Bob in the factory, did you see that? Or slightly better, we're investigating an allegation by Bob that Fred punched him, did you see that? But in both cases, you're putting words into the witness's mouth, and the danger is they'll just say, yeah, I saw him punch him. It is obviously Far better to say, we're investigating an alleged incident at the factory on Friday. Did you see anything? What did you see? Who was involved? Keeping the questions open. And again, in terms of the investigation, you are not simply looking for evidence of guilt. You are conducting an investigation. You're looking for evidence as to what actually happened. And that includes evidence pointing away from the employee's guilt. There is always, as I say, and that's why questions like, did you see Fred punch Bob, are in danger of looking like your investigation is not even-handed. Try to ensure, as far as it's possible, that you ask all the witnesses the same questions, insofar as that's appropriate. If they've all seen the same thing, ask them the same questions. And yes, of course, you need to follow up on any lines of inquiry that come out of the investigation meeting, but try to start on the same footing for all of the witnesses. And again, I apologise, some of this sounds so obvious, but these are all examples that have come up in cases I have done recently where people have paid me to try and put these mistakes right. So I say this, to all of you now, that there is so much you can do to sort of stave off these problems at the outset. And I want to talk now about a very unexciting subject, and that is minutes. Take minutes of the meetings. I've talked about the importance of obviously who conducts the investigation. Every bit as important is the question of who takes the minutes. Because more important than what happened in the investigation is what the minutes say happened in the investigation. And why is that? Because obviously the minutes are all the tribunal will actually usually have. I'm reminded here of the classic line from Sir Humphrey Appleby in Yes, Prime Minister, who's talking to Bernard. And he says, the purpose of minutes is not to record events, this is to protect people. Minutes are there to reflect what people thought they should have said with the benefit of hindsight. Now, I'm not suggesting for the avoidance of doubt the benefit of the recording that you falsify minutes, but the minutes are vitally important because they are going to be the best evidence, possibly the only evidence that you've got to support the contention that the investigation was reasonable. So who should take the minutes? Well, ideally, someone who can type. I'm not being funny, someone who can type them straight out and who can type quickly. If you must handwrite minutes, please make sure they're legible. And if you have someone who takes minutes by hand and then types them up, keep the originals, because you will be asked for them. Make them verbatim as far as you possibly can. This is what I say about being able to type quickly. Because it never looks good, for example, when a meeting is noted as having taken half an hour and you've got one side of A4 of notes for the whole meeting. It's so obviously not going to have captured much, if at all, of what has been said. So the quality of the minutes is hugely important. And above all, send those minutes to the employee and get them to sign them. This is so often overlooked, because if you can get them to confirm that the meeting minutes are accurate at the time, you will save yourself all manner of potential issues when you come to a tribunal, because we spend an unbelievable amount of time arguing over the contents of minutes. If they won't sign them, then write to them, asking them why they say they're inaccurate. Obviously, this point about getting minutes signed goes for obviously all of the people that you interview. We want those interview notes signed by the people who are in the meeting to confirm that they're accurate, because this comes up all the time. And what you don't want, excuse me, is a situation where months or years down the line, you've got smart aleck lawyers, I mean, other ones, not us, coming up with all sorts of objections to the minutes that never occur to the claimant, to the employee at the time. All of that is undercut if you've got the employee sign the minutes at the time to say that it's accurate. And it cuts off an entire potential line of attack. Now, on this point about minutes, I want to just touch briefly on this very topical issue of recording meetings. Should you record meetings? Well, it depends. There are obviously, like so many things, there are points on both sides. It can be extremely valuable for the employer to have a recording of both investigation meetings and subsequent disciplinary and appeal meetings, but it can be potentially damaging, because obviously while you've got what the employee says word for word, you've also got what your managers or your investigator says word for word. And depending on who that is, you might not want that. See the Sir Humphrey point earlier. So I mean, I did a case recently. Now this involved a grievance appeal hearing that ended up in a dismissal. But the employee got angry with the manager in the appeal hearing. He announced he was going to take legal advice. And at that point, the manager replied, "But if that's the case, I'm going to suspend you." Won't surprise you to learn that didn't particularly impress the tribunal when that was played to them. And I was left arguing that, well, grievance and suspension weren't part of the disciplinary, so it wasn't actually relevant to reasonableness or procedural fairness. I will leave you to guess how successful that submission was with the tribunal. But if you are happy to have what your side is saying down verbatim, and if they're being done professionally in these meetings, then you oughtn't to be worried about that. Then recordings can be very useful, because obviously it makes it nigh on impossible for the claimant to deny what was said. But of course, you will need transcripts, and that can be expensive, and it's obviously a a practicality consideration of how you get them done, independent company, how you confirm they're accurate, and so on and so forth. Because while it is sometimes helpful to be able to play a little bit of the audio, particularly where you want to demonstrate the tone of the meeting, if you've got the claimant swearing at their manager and slamming the door as they leave, it's always good to hear that rather than have it written down. The tribunal will not want to listen to long recordings. They will make point blank refuse, and they will want to know why they haven't got the transcript. So you will need transcripts. And again, as this point about providing that information to the claimant, you probably need the transcripts at a relatively early stage. So you may conclude that that's impractical from a sort of a financial point of view, but it's worth considering whether to record meetings, and obviously make sure that the employee is aware it's being recorded. You don't necessarily need their consent as such, but I would have said you certainly need to make them aware. Obviously, covert recordings by employees are quite common. Tribunal frowns on that, but you need to be front and center about your desire to record it. Ideally, get their consent if you can. So in terms, as I say, of the investigation, the quality of the note-taking, whether that's written or typed or recorded, is going to be central. And again, depending on the allegations and the seriousness, you may want to take formal statements from the witnesses. Again, if you do get these done properly, type it out in a certain, it hasn't got to look like a court witness statement, but some sort of, formal looking document that says it's a witness statement and has the date and is signed by the employee, would obviously help. You often see it just as an email to a manager. If you can, the more formal you can make it, the better, because again, it goes to the seriousness of how seriously you're taking the allegations and the reasonableness of the investigation that you're undertaking. And again, be prepared to provide those to the employee. There may be issues with redaction, depends what's in there, but it's going to be central to fairness, as we're going to come on to talk about a little bit later, that the employee knows the case against them, and that's going to include understanding the evidence. And just finally, on the investigation, and I've spent quite a bit of time on this, but it is so important, and this is a point that is often missed. Produce an investigation report. It is so often the case that you don't get this, and it hasn't got to be a leather-bound volume running to hundreds of pages, but tie the investigation together. And why is that? Because the person doing the investigation is and shouldn't be the person doing the disciplinary. And the purpose of the investigation is to decide whether there's a case to answer. Now, again, following the logically through, if this proceeds to a disciplinary hearing, if the matter goes to a disciplinary hearing, that can only be because the investigator has decided that there is a case to answer. So what the tribunal is going to want to know, and what you're going to want to be able to demonstrate, is what is the basis for that decision. Before we even get to what happened in the disciplinary hearing, why did it get as far as disciplinary hearing? Answer: somebody looked at the investigation and decided that there was a case to answer. And we would like to know why. So a simple report by the investigating officer saying, I was asked to investigate XYZ allegations. As part of my investigation, I spoke to these people on these dates. And obviously, that may or may not include the claimant, as we've said. Notes or statements were taken. I looked at these documents and this other evidence. I looked at the company's disciplinary policy, always helpful, and I decided there was a case to answer for these reasons. That's all it needs to be. But so often you have an investigation with no evidence as to who decided that it should go to a disciplinary or why. And it's so easy to avoid that if you can just put in a simple investigation report showing how and why the decision was reached. And then when the case does go to a disciplinary, it's all the easier for the person drafting the invitation and also for the disciplinary officer to know what they're dealing with. So by this point, we've conducted a reasonable investigation. We've now got a genuine belief in misconduct, which is also therefore hopefully going to be reasonable. I want to talk now a little bit about what I've called framing the charge. And this is all about the disciplinary investigation letter. And the central principle here is that the employee must know the case against them. What precisely are they being accused of, and what is the evidence for that allegation? And it needs to be absolutely clear at the disciplinary invitation stage. And again, this is the point at which to provide them with the disciplinary procedure as well. Make sure they're sent that. Don't just say it's in the employee handbook. It's got to be clear to them from that letter why they're being asked for a disciplinary hearing, what it's about, what's the evidence behind it, and what's the procedure going to follow. And the reason it needs to be clear at that stage is that the invitation contains the disciplinary charge, and that sets the parameters for what follows. And I do want to talk here about a particular case, and this is a case of Struthlos and London Underground Limited. It's a Court of Appeal judgment from 2004. And that case is authority for a number of propositions, but they can be summarised in this way. Firstly, that an employee should only be found guilty on an offence with which they have been charged, i.e. that's set out in the disciplinary invitation letter. That care should be taken in how that disciplinary charge is framed, and that there is only very limited circumstances in which it's permissible to go beyond that charge in deciding to take disciplinary actions. When you come to the sanction, it's very unlikely that you're going to be able to impose a sanction that doesn't relate to what you've set out in the invitation letter. And normally it is only matters that have been charged that can form the basis for a dismissal. So what it's basically saying is you can't move the goalposts during a disciplinary hearing, which is why the dismissal, the disciplinary invitation letter is so critical. Employers sometimes sort of overlook this point and try to deal with it all in the hearing, but you'll spend a lot of time in tribunal arguing about what the letter says and what the employee would have understood the letter to mean. So in that case of Struthos, what had happened was, I won't give you the whole facts of it, but the employee had been charged with taking a company van abroad without permission. It was a van he was entitled to use, but the allegation was he didn't have permission to take it abroad. Now, during the disciplinary hearing, the employer decided that his actions amounted to dishonesty and dismissed him for gross misconduct, but it had never been put to him. It's never been alleged that he was dishonest. Now, the tribunal found that the employer didn't have reasonable grounds for the belief that it was gross misconduct because it had never been put to him that he was dishonest. And that decision was, in fact, overturned by the Employment Appeal Tribunal, but was restored by the Court of Appeal, setting out those principles that I have just gone through. So that's high authority for these points about the importance of the employee understanding the case that's against them, and that the disciplinary only proceeds on the basis of what the charge that's been set out in the letter. So think carefully about the disciplinary invitation letter. Now, as a matter of common sense, is it obvious from the letter what the employee is accused of doing? Because it really does need to be, and you'd be amazed, as I've said, about how vague some of these letters are. It isn't enough to say, when you're giving evidence, well, the employee knew full well because they were there. And obviously, bear in mind, this is also part of the ACAS code. We've said the code doesn't cover a great deal, but in terms of the invitation, it does refer to the importance of setting out the case. And so obviously, if you mess this part up, you are risking an uplift in terms of the code itself. So the ACAS code in respect of notifying the employee says this. It says if it is decided that there's a disciplinary case to answer, the employee should be notified of this in writing. Well, that's that we know. This notification should contain sufficient information about the alleged misconduct or poor performance and its possible consequences to enable the employee to prepare to answer the case at a disciplinary meeting. And finally, it would normally be appropriate to provide copies of any written evidence, which may include any witness statements with the notification. So a point that came up in a recent case I did, the judge, in fact, put it to one of my witnesses, could the employee, on reading this invitation letter and nothing else, know why they were being summoned to a hearing? And he had to admit rather sheepishly that they wouldn't. It gives you an obvious problem with procedural unfairness if your letter doesn't make it clear exactly why they're being asked to a disciplinary hearing. And while there is case law to say they don't have to have seen witness statements, it's obviously going to be better. You're looking to show that you've acted reasonably if they have seen them in advance, because you're going to rely on them at the hearing. So again, if they're provided to the employee in advance, subject to any redaction obviously, then that's going to be better. And just one final point on that ACAS code point. We've talked about the importance of making sure the employee's got sufficient information about the misconduct and also its possible consequences. Now, this is a standard paragraph in these sorts of letters about, sanctions that may follow, including up to dismissal. But I have seen invitation letters which say, we consider this amounts to gross misconduct. Don't give the claimant an open goal to shoot at the allegation this is a foregone conclusion. It is potential gross misconduct at this stage. It's so important. You are trying to persuade the tribunal at this stage that you have acted reasonably and that you are giving the employee a fair hearing. So if your invitation letter suggests you've already worked out the answer, it's obviously not going to do you any favours at all. So that's why I've spent quite a bit of time again on the invitation letter, because it is not a mere formality. It is a central part of the disciplinary hearing, and the reasonableness of the outcome of the disciplinary is going to be directly tied to what you have in the invitation letter. And that's my point, obviously, about the better your investigation is and the better your investigation report ideally is, will make it easier to write a disciplinary invitation letter, invitation letter, and then will improve the chances of the actual disciplinary proceeding fairly. So again, when you then come to hold a disciplinary hearing, obviously consider who's going to conduct it. make sure they haven't been involved previously, and that they are of appropriate seniority to take a decision to dismiss. And all the same points apply about the minutes, obviously, whether you record it, but the notes that you take there are as crucial for the disciplinary hearing as they are for the investigation. And again, just in terms of the ACAS code, we'll obviously make sure the employee's been given the right to be accompanied, hold it without unreasonable delay, give them a reasonable amount of time to prepare their case. You might want to invite them to put in written submissions. Now, they may find this helpful, particularly if they're nervous, but it may also help the employer. Because if they don't raise lots of points at there, but they later want to rely on a tribunal, and the same goes for an appeal. So it's worth trying to get them to, as I say, with sort of their objections to the minutes, nail those down at the time. If they've got points they want to make, get them to commit to those then, because obviously later when they've had lots of advice and they've got, a barrister trying to sort of tease out the points that they claim wishes they'd said at the time, if you've got it clear at the time what the claimant's case was, that's going to limit their options to try and sort of expand the allegations later on, particularly if it's not pleaded in the ET1. So written submissions can often be quite helpful. Allow them to call any witnesses and consider the decision. I know that sounds ridiculously obvious, but take the time to consider the decision. Adjourn the meeting. Professional judges may give extempore judgments off the top of their heads. Not a good idea for dismissing managers. And the reason why, obviously, apart from making it clear to the employee that their case has been given serious consideration, but it gives the decision maker time to record the reasons for the decision. And that is both the decision as to whether they're guilty or innocent of the misconduct and the decision on sanction, because both of those are going to be important for showing that the dismissal is fair. And make sure, and when you come to do the disciplinary outcome letter, which obviously in this case is going to be a dismissal letter, make sure that it spells out what findings of fact have been made by the decision maker. If there is a particular, dispute of fact between the witnesses and they are concluding that, the employee is guilty, they're obviously having to prefer one person's evidence over another. We're not expecting a tribunal judgment here, but the more information they can put in as to how they've come to their decision, the better. So we want to know what reasons the decision maker has for believing or concluding, I should say, that the employee is guilty of some or all of the misconduct. And if it isn't all of it, then deal with it. Show which parts of the allegations you uphold, which parts you don't, and why. And also give the reasons for the sanction, because obviously this point about dismissal is often overlooked because so many employers leap from a finding of guilt on the allegations themselves to dismissal without explaining why. And then you are left dealing with that aspect in a witness statement at tribunal when it really should be front and center in the dismissal letter. So for example, just because the disciplinary policy gives examples of gross misconduct, which hopefully it does, and just because it says that gross misconduct can lead to summary dismissal, it doesn't mean it has to. And it's obviously going to be particularly important in cases where there isn't a prior disciplinary record. And as we all know, this is my experience as an employer, often the most problematic employees have no previous warnings because there's been a wholesale failure to deal with problems in the past. And then you've got to be so careful that the sanction that you impose as a disciplinary officer who's dismissing is relating to the misconduct they've actually been charged with on this occasion and not what everyone knows is lying in the background. And this is back to that point case of Struthos. The decision's got to relate to what the employee was charged with. So, think carefully about that. And again, also remember this is conduct we're talking about here, not capability. So if make sure if you're talking about something that could be negligence, you need to have made sure at the beginning that this is clearly a conduct issue. But what the letter needs to show is not simply why the decision maker found that they thought the employee was guilty of the misconduct, but why does this decision maker in this case believe that dismissal is appropriate? And above all, what other options have they considered? So when we come to consider the band of reasonable responses, yes, it is a broad band. Yes, it is not for the employment tribunals to substitute its judgment, but make it easier for them to find in your favour. Give thought to alternatives to dismissal or action short of dismissal and show you've done this by writing it in the letter. Don't say, as employers have done often, we have no alternative but to dismiss you. That may be your ultimate conclusion, but show you've considered alternatives, because a dismissal, even for gross misconduct, can still be outside the range of reasonable responses. So if it's obviously a case where dismissal is appropriate, well, so much the better, but still spell it out. And obviously, if it's not a case where it's obvious that dismissal is appropriate, then it's all the more important, and the tribunal is going to be all the more impressed by a record of the reason for the decision that's taken at the time. So if you adjourn the meeting for half an hour or an hour or whatever's appropriate and spell out your reasons in writing, that is going to be far more useful to you when you're then trying to defend a claim than a witness statement that might be made 2 years later. Or worse, you find the decision maker has left by this point. You can't get them to come to the tribunal as a witness. You're left with the outcome letter that may not have the full reasons. Contemporaneous records are your friend, obviously, in all things, but particularly, again, when it comes to this issue of the reasonableness of the decision, because the best placed person is going to be the decision maker themselves. And again, when you're coming to the conclusion on sanction, take into account relevant circumstances. So look at this disciplinary record, look at length of service. It's not a get out of jail free card, but it is clearly relevant. And you can guarantee that the claimant is going to raise those points. If you have a long-serving member of staff with a clean disciplinary record, they are going to raise that at every opportunity, starting with the appeal and throughout the tribunal. So if you can preempt that by dealing with those points in the actual decision letter, then so much the better. And this is one other point actually that came out of the case of Struthos, is that length of service is a factor the Court of Appeal found that can properly be considered in deciding whether an employer's reaction to the employee's conduct is appropriate. So if you can show you've considered that, then that is obviously going to be helpful and should go to the reasonableness of the decision to dismiss. And obviously, other factors are going to be things like whether the employee has accepted their, admitted it, they've showed remorse, or whether they're in circumstances they're under stress or being provoked. If you're aware of those factors, deal with them. Because you can be sure the employee will raise them. And finally, on this point, make sure that your decision is consistent with comparable decisions that you've taken, even if you're not, that the company has taken. If you've given Fred a final warning for punching someone, you sack Bob for punching someone, you can be sure Bob will know about that, and you'll end up having to explain the difference in treatment. And if you're unlucky and Bob's got a protected characteristic, you'll look at a discrimination claim as well. So, be careful, consider the consistency of the way in which cases are being treated. And obviously, the more of this that is in the outcome letter, the better, because the stronger that letter, the more chance you have, obviously, of insulating yourself against an appeal, let alone a claim. And so I will deal very briefly, because I'm conscious of the time. I've been talking for about 40 minutes now. But in terms of appeals, it is important not to drop the ball at this stage. The ACAS code obviously extends to appeals. The same points about procedural fairness all apply to the appeal stage. So ensure that the employee's points of appeal are understood from their letter. Often they'll be very vague. We all know there's only one reason for appealing. It's because you don't like the decision. But get them to spell out what it is that they're not happy with. If they say the process isn't fair, what wasn't fair about it? If you can tease this out of them at this stage, and that's my point about written submissions, it's far better to say the employee made this allegation and this allegation at the time, and then you're not looking at an ET1 with 14 allegations of procedural unfairness drafted by their lawyers and the claimant's barrister, doing all of that in the tribunal. If the employee was actually only concerned about you didn't speak to so-and-so witness, or, some other specific allegation, well, you can just deal with that point. So, as I say, written submissions are often helpful because you'll get it from the sort of horse's mouth what they're actually unhappy about at the time, as opposed to later on. Now, obviously, again, make sure someone independent conducts the hearing. Make sure I have all the documents they need. So silly when you're getting witnesses cross-examined who say, actually, I never saw the claimant's, complaint letter, or I never saw that witness statement or something. And you think, why not? And you're not expecting it because you just assumed it would have happened. Make sure the person who's doing the appeal has got all the documents they need. And again, if you've got an investigation report, you've got a clear invitation letter, you've got a clear outcome letter, that will all make the person's job who's handling the appeal that much easier. If the claimant raises issues that warrant further investigation, then investigate them. Be seen to be reasonable. Again, put yourself in the claimant's shoes. This is your chance. If you have, procedural failings at an earlier stage, the appeal obviously is your chance to cure those. So don't squander it, and don't introduce new procedural failings if there aren't any to begin with. But do make sure the appeal is not just a rubber stamp of dismissal for the original decision. It doesn't have to be a complete rehearing, but you may want it to be. You may simply want to address the points that the claimant's raised. But either way, your outcome letter should make clear which approach you've been taken, and again, the reasons for the decision. I've seen so many appeal letters that just say, I can't find anything to fault the decision by so-and-so the manager. That can be enough, but it would always be better if there was a more detailed. It just shows that it's genuinely been considered and it is a fair procedure that's been adopted. And again, if you've got the appeal decision maker recording the reasons for their decision at the time, again, all the same points about adjourning apply to the appeal as well. That is going to be far, far better than calling them as a witness 2 years down the line and trying to get them to remember the reasons why they didn't upload the appeal. So essentially, just to sort of summarize what I've said so far, reasonableness is your watchword throughout all of this. The investigation is central, absolutely critical, and the quality of the minutes or the transcript is the foundation for a solid case that proceeds from there. You've got to make sure the employee knows the charge that's against them, and it's precisely framed, and that is the basis of any subsequent disciplinary sanction. Make sure the claimant has seen the evidence against them, and record the reasons for the decision at the time. And independently, ideally independently of the outcome letter, and then make sure the outcome letter explains what that decision is, why it was taken in terms of the findings of misconduct, and then why dismissal was appropriate and what alternatives have been considered. And obviously, the appeal is equally deals with those points. Now, see, none of that is going to prevent a claim. We know this. You can do everything right and still be facing a claim, but it ought to make defending a claim a lot easier. And I hope that that has been helpful. There are some questions that have popped up in this little box that I haven't had a chance to read. So just give me a second. I'll have a look at those. So the first question I've been asked is whether it is reasonable. We've got situations where the person who's bringing the allegations is also appointed as the decision maker, though separate to the investigator. Is it reasonable for the person bringing the allegation to be the decision maker? I would have said it's going to be very unlikely to be reasonable, because obviously the key here is that the employee is getting a fair hearing. And if you are the one alleging that they've done whatever it is that amounts to misconduct, you're clearly not going to be an appropriate person to decide if that's actually happened, because you're going to be judge and jury in your own case effectively. So I would have said, I mean, I appreciate in small businesses, you're often limited as to what you can do, but certainly the person alleging misconduct shouldn't be the person making the decision. I mean, if the employee has literally, sworn at the managing director and there's nobody else, well, you're going to have to think how you can, you can bring somebody independent in, because otherwise it's going to be, you're running the risk of procedural unfairness finding on that alone. So I hope that answers that question. And I've got a question about what if you're concerned the employee will destroy evidence or manipulate other employees prior to the meeting? I'm assuming that refers to the investigation meeting. Obviously, it could presumably go to the disciplinary. Well, obviously, that's where you may want to suspend. And that, that's so obviously, suspension is often where you're concerned that obviously somebody may influence the course of the investigation. So if you genuinely thought that that's an issue, then that might well be the case in which you want to suspend them on pay. Although again, you have already advised you to give reasons for suspension. I would certainly therefore be careful about making an allegation in writing in a suspension letter that you think they're going to destroy evidence. I would want to phrase it much more neutrally about ensuring that the investigation isn't compromised, or something a bit more, what's the word, neutral than that, if you see what I mean. But certainly, I mean, that's why, again, you don't always want to talk to the employee or tell them there's an investigation, because employees always cry blue murder if you investigate without telling them. But again, that's precisely why you might want to do that. But certainly, if you've got those concerns, then I would think that's got to be an appropriate situation for suspending. And I've got another question here. Is it sufficient for an employer to refer to the disciplinary process and send a copy of this with a covering letter inviting the employee to a disciplinary meeting in order for a subsequent dismissal not to be held to be procedurally unfair? Well, no is the obvious answer to that, simply because obviously there's, as I've hopefully tried to set out, there are a lot more elements to a procedurally fair dismissal than simply following the procedure. It's going to be, as I've said, relevant to the allegations against the employee. The procedural fairness is going to be looking at these points that we've covered in terms of whether the investigation is reasonable, whether the employee's had a chance to, has been made aware of the allegations against them, whether they've got the evidence, whether they have been able to call witnesses, or they've been allowed to be accompanied, all the points that we've covered. So yes, you absolutely need to send them the disciplinary procedure and at an early stage, but there's obviously going to be more to it than simply doing that. Following your own policy is obviously essential, it's going to be difficult for you to say that you've acted appropriately and reasonably if you don't follow your own policy, but it's going to be more to it than that. And I've got another question down here, apparently. So would you provide the employee with a disciplinary investigation report itself as standard as part of the investigation and closures and potential issues? Well, thinking about that, I mean, if you get to a tribunal, you're going to include the disciplinary investigation report in the bundle. You're going to have to, because it's a relevant document. I would have thought, therefore, that there shouldn't be anything in the investigation report that the employee shouldn't see, unless there's some confidential information in the witness statements or something that might need to be redacted. In principle, the investigation is into the allegation that the employee has committed the misconduct that's alleged and is going to be reviewing the evidence that establishes for or against that. So in principle, there shouldn't be anything I would have thought that the employee shouldn't see. Obviously, think carefully about how you write the report, but then again, it's going to be seen by a tribunal, so that goes double for that anyway. So I would think it's going to be desirable to provide the employee with that, because obviously, if you've done the investigation reasonably, the earlier it becomes the employee's aware of that, the harder it's going to be for them to say that you haven't done X or Y. And then if they don't accept you've done it reasonably, well, that's their chance to say so. And if they don't then raise issues at that stage, but the issues are raised further down the line, well, that then begs the question of why, if this was genuinely an issue at the time, it wasn't actually raised. So I hope that answers your question. I've got a couple more comments that popped up in the chat. Yes, I will try and summarize this webinar, and if people find that useful, thank you. And finally, what should be done in the event that an employee refuses to sign a notice as an accurate reflection of the meeting, particularly as we're conducting most online, so they can't be signed there and then, or if the employee submits their own version, which is disputed? Well, as you'll be aware, employees will often refuse to sign notes as a matter of course, because they just don't trust the employer. It's easy for me to say, get them to sign it. But obviously, if you can get them to sign it, great. If they won't, as I said, I would advise putting something in writing from the employer to invite them to set out what it is that they're going to agree with, because it's obviously not enough just to say the minutes are inaccurate. They may not respond to that either. But again, in terms of being seen to be reasonable, if the employee submits their own version, which you don't agree with, obviously then you want to be able to go back to them saying why you don't agree with their version, so that you've got that set out at the time, even if they won't tell you, what it is that they're not happy with in yours. But as I say, anything you can do at the time, particularly given the length of time that elapses usually before the case is getting to tribunal, anything you can deal with at the time to try and nail down the contents of what's actually happened in meetings is desirable. So you won't simply be able to guarantee that that can happen, but if you can, I would strongly advise it. And another question, do you think an employee should be given access to witnesses to ask direct questions during a disciplinary process, or can the employer prevent this by asking questions on the employee's behalf? That is a tricky one, because obviously you don't want a situation where the employee is effectively being allowed to intimidate someone who's made an allegation against them. I mean, obviously, the employee is entitled to bring their own witnesses with them, obviously, that support them, but you wouldn't normally invite the witnesses, in my experience, who have provided evidence that is forming the basis of the charge to the disciplinary hearing itself. If the employee is challenging what those witnesses have said, then it may be appropriate, depending on what the challenge is, to adjourn and make further investigations or to put particular questions to those witnesses. But I wouldn't have thought it would ordinarily be appropriate to give the employee a chance effectively to question someone who's making an allegation against them, because that could raise all sorts of difficulties, particularly somebody being the suggestion that somebody's intimidating somebody else. So I think it would be more appropriate there for the employer to sort of deal with that as part of further investigation. And obviously, the more time that's spent investigating it, the more able you're going to be to say that the investigation that you've done is reasonable. So I hope that that answers the questions that I've had. And I hope you found this useful. Thank you very much, as I say, for your time in attending this afternoon. Obviously, if I can be of further assistance, do please get in touch with my clerks. We'll have our contact details on the website, and I will endeavour to reduce that into a sort of fairly bullet point handout with just hopefully some of those tips, so that hopefully that will be of use to you and to your clients. So thank you very much indeed, and good afternoon.